A guy who got so drunk playing beer pong, then left the bar, went home, crossed a highway, got hit by a car, suffered serious injuries, is now suing the bar, or trying to sue the bar. We're joined by WGY legal analyst Paul Harding of Martin, Harding & Mazzotti. Good morning, Paul.
Good morning, Kelly. Good morning, Chuck.
Hey, Paul.
So this is kind of an interesting case. This guy thinks that the bar should be held responsible for his actions because there was a beer pong contest that he was involved in at their establishment.
Yeah, we like to say he gave it a shot. It looks like,
That's right. Threw it against the wall.
Yeah, I think so. It's not going to work out. And it's the right decision. It's a decision that if it had gone the other way, would have been discussion in coffee houses and courthouses across the country. Yeah, the claim is that he, in fact, was overserved. And, of course, that's always a bit of a running joke when people drink too much. Historically, the bars, they are responsible if they overserve someone, and then that person goes out and injured a third party. But he gave it a shot, didn't work out.
What did they try to say, that the bar set up this mechanism for him to get drunk and then didn't pay attention to his intake?
Yeah, the strongest argument was that they organized and set up the tournament, and then they failed to monitor it. Now, if I don't know, Chuck, if you've ever played Pong, you want to make an admission this morning?
I've not played Pong, but I have engaged in drinking games. I'll say that much.
Okay. It is a game where, he was on a table for 3.5 hours. Now, 3.5 hours of really just continuing drinking. So they're saying there was a table set up, there was unlimited amounts of beer, and there was no one monitoring the game to see that he overconsumed. So that was the strongest argument, not the best argument. One of those cases that if they had called, my office, it wouldn't have gotten very far. We wouldn't have probably talked to them for more than 2 or 3 minutes. But they really felt that they should have done more monitoring of it, and it was an argument, and the argument failed.
Well, the other argument that I thought was kind of useless was that his attorney said that because he was winning and he never left the beer pong table.
Yeah, he's good at it. Yeah.
But the other thing is, if you're winning, you're not the one drinking. If you're the one who loses, then you're the one who's drinking all the beer. So his argument is which one is it? Either he was winning and not drinking, or he was losing and being forced to drink.
Well, what happened is I took a look at some of the Pong rules in New York City. It's a 2 out of 3, so you can stay on the table and still have to drink 2 shot glasses of beer with each victory. So I thought the same thing. If you're winning, you're not drinking, but there you can still drink at every win. You can have as many as 2 shots of beer. So potentially, if he was winning, the majority of it, he was still drinking and staying on the table for 3.5 hours.
So I guess the bottom line here is that even though New York State has the law about over-serving, it only applies if the person injures someone else, not if they injure themselves as a result of their overindulgence.
That is absolutely where the law was intended. I guess there's a set of facts that could exist. They don't exist here, where the bar is serving somebody, and make the argument that they're meant to serve them 8 ounces of beer, and they're serving them 12-ounce beer, and they're labeling it wrong. So the guy's doing his math, trying to stay consistent with what he thinks is going to make him continue to be sober and able to drive or able to function. So there are a set of facts that might exist, but they're extreme, and I've never heard of them.
Well, the other thing is, if this case had been allowed to go forward, then it lays the groundwork for a whole lot of kind of frivolous lawsuits where someone gets drunk and falls down and sues the people who served them, and that kind of thing.
Yep, you're absolutely right. I don't think it ever had a shot. I think they sued it, hoping to shake down the insurance company for a few dollars. Yep. The insurance company took a no-pay position, and then they were kind of locked in the lawsuit and said, well, we'll see where it flies. And no, it borders on an embarrassing claim.
Thanks, Paul. Always fun.
Okay, guys.
And I come away with this. I wish I'd gone to school with both you guys. I think you guys know. You guys seem to be a little enthusiastic, a little bit knowledgeable about this stuff.
And it's the New York City rules versus the Oswego rules. Yeah, they were completely different.
Much more liberal at Oswego. Hey, thanks, Paul. Take care, man.
Bye-bye.
Paul Harding from Martin, Harding & Mazzotti, 1-800-LAW-1010.